Good morning, everyone. It's Gordon Barr speaking. By way of introduction, I'm a partner in the employment incentives practice here at Altamimi. First of all, thank you all for joining us. I am also joined today by my colleague Martin Hayward. Martin is a late but very welcome addition to the presenters this morning. Martin is our head of technology, media and telecommunications practice. And Martin's joining us today because there are a few privacy and cybercrimes perspectives that he can speak to better than I. So the reason obviously we're here today is to talk about the new presidential directive, which was introduced last week, and the associated emergency measures that are contained within it. We have an hour allocated for the webinar, and there's plenty of time afterwards for questions. You will see on your panel that there is an icon which allows you to submit written questions, and at the end of the presentation we can review those questions and address them in the time that we have remaining. If it's not possible to address all questions, then our email addresses are also provided in the slide deck, and Martin or I will be happy to revert to you with any queries that we don't have the opportunity to address. So without further ado, in terms of the agenda for this morning, we're going to set the scene and introduce the subject matter, look at the emergency employment measures, consider the COVID-19 related sick leave implications, wrap up all employment and indeed visa considerations, and then I'll pass over to Martin, as I say, to consider the privacy and cyber security elements, followed by the Q&A. So in terms of the directive itself, it's Presidential Directive number 4 of 2020 in response to COVID-19 emergency measures. It's effective from the 21st of April. It was announced a couple of days later, about a week or so ago, but effective from the 21st, and it's in effect until the 31st of July 2020, subject to any extension by way of a decision by the President or likely by way of further directive if there is any extension. So during this webinar, where I make mention to the emergency period, I'm talking about the period between 21st of April and 31st of July, subject of course to any further extension. So the purpose of the directive is, I suppose, to an extent self-evident. We're obviously all in a very difficult situation, and the business community is having to react to that, and this presidential directive is designed to try and limit the impact upon employers and employees. And you'll see when we go through the material that there are some provisions that are more favourable to employers and others more favourable to employees. Obviously, this directive has followed closely on the heels of the onshore ministerial resolutions, which were issued by the Ministry of Human Resources and Emiratisation to provide certain measures which apply onshore. And I'm aware from some of the attendees on this webinar today that some of you have businesses both in DIFC, for which this presidential directive is applicable, and some of you have businesses onshore, or a combination of both. Obviously onshore, the ministerial resolution, the primary one being resolution 279 apply. And you'll see that there are some differences between the onshore ministerial resolution and the presidential directive that we are looking at today. So in terms of the emergency employment measures, and I suppose this section is the one that has grabbed the most press attention when it was announced last week, which provides that a DIFC employer may lawfully implement certain measures without first obtaining employee consent. And without first obtaining employee consent is the material wording, in the sense that ordinarily In usual circumstances, any variations, of course, to terms and conditions of employment would require employee consent. Whereas during the emergency period that I mentioned before, measures can be imposed by the employer without obtaining employee consent. And those measures are reducing working hours, imposing annual leave, imposing unpaid leave, reducing remuneration on a temporary basis during this emergency period, restricting workplace access, and imposing remote working conditions, including, for example, measuring employee engagement and productivity during remote working. In terms of that last point, where we talk about imposing remote working conditions and requirements, the directive specifically provides that certain provisions within the DIFC employment law, which relate to health and safety, temperature within the workplace, lighting, cleanliness, room dimensions, drinking water, etc., which are housed in Articles 43 to 53 of the DIFC employment law, do not apply, because obviously it's going to be difficult in this current period for those type of workplace assessments to take place in employees' homes. So that is the emergency measures that are in place, and the employer is required to provide employees with written notification of the employee's decision to implement one or more of these employee measures, and the employer has to give the employee 5 days notification in advance of the implementation of one or more of those measures. So an obligation upon the employer to write to the employees to notify them 5 days in advance that the changes will be taking effect. So you're possibly wondering at this juncture how this presidential directive sits with the DIFC employment law and the DIFC contracts law, which provide ordinarily that employee consent is obtained for changes. Well, essentially, this directive makes specific provision that it supersedes those provisions under the employment law and the DIFC contracts law for the duration of the emergency period. And for those who are joining slightly late to the webinar, that emergency period being 21st of April to 31st of July. So these measures will aid employers, no doubt, in terms of their strategic decision making and financial modelling that they need to do, and in many cases, some or all of these measures were under consideration by DIFC employers in any event prior to the introduction of the directive. Turning to sick leave and COVID-19 related sick leave. This is a section of the directive which is to the advantage of employees and aids employees in circumstances where it is necessary to take sick leave during the emergency period as a result of unfortunately contracting COVID-19, whereby a sick leave certificate requires to be issued by a competent authority being, for example, the Dubai Health Authority or the Ministry of Health and Prevention, or in circumstances where that competent authority has placed an employee in quarantine to try and prevent or avoid the spread of COVID-19. In either of those circumstances, the employee's sickness absence shall not count towards their sick leave entitlement under the DIFC employment law. And by way of a reminder, employees in the DIFC have a sick leave entitlement of 60 working days. So any COVID-19 absence as a result of the bullet-pointed provisions around sick leave certificates being issued or being placed in quarantine by the competent authorities will not count towards sick leave entitlement. Furthermore, employees will be entitled to full pay during any COVID-19 related sickness absence. And again, as a reminder, under the DIFC employment law, ordinarily sick pay provisions work in such a way that the first 10 days of sickness absence are on full pay, the next 20 days are on half pay, and the remaining balance of any sick leave is unpaid, whereas during the emergency period, any COVID-19 sick leave will be on a fully paid basis. Furthermore, those employment measures that I mentioned a moment ago cannot be applied to employees during their sick leave period where they are absent by reason of COVID-19. And then finally, the last of the sick leave / pay considerations to bear in mind is that the DIFC employment law provides that if an individual exhausts their 60 working days sickness absence, it's possible for the employer to terminate. Given the terms of the new directive, where the employee has exceeded that limit, but by reason of COVID-19 related sick leave, it will not be lawful for the employee to terminate in those circumstances. So that summarises the sick leave and sick pay provisions which have been put in place to protect employees during this time. In terms of other employment considerations, there is now provision for a virtual job market, which again to an extent mirrors the onshore requirements, where there is a virtual job market created for employees who are displaced and have their employment unfortunately terminated or due to be terminated by reason of COVID-19 related reasons. And where employers terminate employees from 1st of March until the end of the emergency period on 31st of July, and indeed any employees that are deemed surplus to requirements, the employer has an obligation to maintain a list of such employees and provide the list to the Government Services Office in DIFC so that this virtual job market can be created. The list that the Government Services Office will maintain will be known as the DIFC Available Employee Database, and other employers will be able to access that database to establish if there are any employees that they wish to potentially hire, and if what the employer rather is required to do is if any employees are on such a list, the information needs to be provided to the Government Service Office in the form of the employee's name, DIFC card details, and the termination date. And we've included in the slide the email address that that information requires to be sent to. Before sending any such information, it would be necessary to obtain the employee's consent to provide such information to the DIFC. Another couple of considerations to bear in mind are around dues and gratuity. To take a step back, and those on call, no doubt telling you what you already know, but the dues scheme came into operation from 1st of February of this year, dues being the DIFC Employee Workplace Savings Scheme, with the concept of end of service gratuity being phased out from, or the accrual being phased out from 31st of January of this year. So the question arises as to what effect the directive has on these two entitlements. So turning to dues first, if we use a scenario, for example, of an employee for whom the employer applies one of the emergency measures, let's say the reduction in pay or unpaid leave, the question is whether or not there's any payment protection in respect of dues contributions. So if an employee was on 20,000 dirhams a month and had 2 years service, the dues contribution would ordinarily be 5.83% on the monthly wage of 20,000 dirhams basic salary. If the employee was, let's say, placed on unpaid leave for the duration of the emergency period, then there was no specific protection. So because there is no wage being paid in that payment period, which is that particular month, then there is no dues contribution that requires to be made by the employer. Conversely, in respect of end of service gratuity, there is provision rather made within the directive to protect employees. So if an employee's basic salary is reduced after 1st of March 2020, then in circumstances, now again, sorry, just to take a step back, obviously with end of service gratuity that's accrued to 31st of January, there are two main options. One, the employee leaves their end of service gratuity accruing with the employer, or two, the parties agree to contribute that end of service gratuity that's accrued into the dues scheme. Assuming the former applies, then just because the pay has been decreased during the emergency period will not affect the end of service gratuity. So using my example before, if an employee was on 20,000 dirhams a month and it was reduced to 15,000 dirhams on let's say the 15th of March for the purposes of the emergency period, the employee would still benefit from the salary that he or she was being paid as at 29th February, which is the 20,000, and their gratuity accrual would not be affected. Likewise, if the parties agreed to go down the latter approach, which is funding dues with the end of service gratuity contribution, which had accrued, then again it would be based upon the salary which was in effect at the 29th of February and not the reduced salary that was applied thereafter. So certain protections around end of service gratuity have been foreshadowed and built into the directive. Another area that the directive has addressed is around visa cancellation. Ordinarily, the DIFC employment law provides that there is a statutory limitation period, sorry, a statutory period within which the visa should be cancelled, which is 30 days after the termination date. And there's provision for that within the DIFC employment law. Under the directive, visa cancellation may be deferred beyond that 30-day period. So if an employee's employment is terminated today, the visa cancellation can be deferred up to and including the 31st of July, which is the end of the emergency period. And that gives some welcome respite to employees who have unfortunately had their employment terminated during this period. During the period where an employee's employment is terminated, but the visa remains valid, there are no rights or benefits that continue to accrue under the DIFC employment law, with two exceptions. One being that medical insurance coverage requires to still be maintained whilst the visa is active. And secondly, there is a specific carve out for employees within the retail, service or hospitality industry who are provided with accommodation rather by their employers. Employees who fall into that category will continue to have the right to have that company provided accommodation until the time of visa cancellation. In terms of further employment considerations, there's also provision for wrongful trading rules to be suspended for directors. So the DIFC insolvency law provides certain rules around wrongful trading to restrict the actions of directors. So if a director knew or ought to know that his or her actions may or the actions taken on behalf of a company are being taken in circumstances where insolvent liquidation is a distinct possibility, and then creditors and other third parties may ordinarily take action against directors, and directors may have a personal liability if they haven't complied with the terms set out in the insolvency law. And those particular provisions within the insolvency law, articles 113 and 115, have been suspended for the emergency period until the 31st of July to allow directors to continue to trade, incur new credit, and make decisions that may otherwise give cause for concern around personal liability. So essentially to take that pressure off company directors during this emergency period to try and give businesses that are, for want of a better expression, teetering on the edge, some room to manoeuvre. In addition, there is provision for workplace restrictions, and the DIFC authority can issue directions, and indeed has done, to restrict employees workplace attendance, and specify vital roles in key sectors that require a presence in the DIFC either during or after working hours, and issue directions as to which permits need to be applied for and which directives need to be adhered to, whether or not they're DIFC directives or federal or Dubai government directives. And of course, we've seen some of those circulars and directives thus far, the latest one being on the 26th of April, just a few days ago, making provision for up to a maximum of 30% of the workforce in the office, which is a relaxation of where we were before, but to avoid high-risk individuals such as pregnant employees, and other precautionary advice around face masks, temperature screening, social distancing, and so forth. And if the employer is found to be in breach of those DIFC directions, then there is provision under the directive for a pretty hefty fine of up to $50,000, and provision for employees to face the risk of immediate summary dismissal, and that is for cause under the DIFC employment law if they act in breach of the directions given by the authority. At this point, I'm going to pass over to Martin, and Martin's going to, as the slide would suggest, look at some privacy and cybersecurity implications within the directive.
Thanks very much, Gordon. So one of the things that the DIFC directive has done is take the opportunity to address some certain key privacy and cybersecurity issues. And this is very much following, we've seen similar come out, and Gordon mentioned earlier, from the Ministry of Human Resources and Emiratisation, and we've also seen certain guidelines released by Abu Dhabi Global Market. And really the focus of this is that DIFC companies have largely moved to remote working. Now, there may be a number of those companies may already have a culture of remote working, but a lot don't. They've instituted new IT systems, new ways of working, new processes and procedures, and they've done it very quickly. Also, what they're doing is collecting a lot more data, a lot more personal data, a lot more sensitive personal data, particularly health data about their employees. This is something they haven't done before. So one of the things that the directive does is really reiterate some key messages around privacy and compliance with the DIFC data protection law. So we've got 4 key points on the slides. We'll work through those one by one. This is all Article 13 of the directive. The first one talks about the requirement to either notify employees where DIFC employers are monitoring IT systems and IT equipment, or if the employer decides not to notify their employees that monitoring is ongoing, that they have fully documented what they're doing. So if they get a request from an employee for information in terms of what monitoring is taking place, that they're able to provide that. And the key there is that they're able to demonstrate that any monitoring activity that is going on is commensurate and proportionate with the employee's data privacy rights under the DIFC data protection law. So a number of key things here for employers to think about, because it may well be the case that some DIFC employers have remote working policies already in place. If they don't, they may want to be looking at things like their acceptable use policies that govern how employees interact with the IT systems at work, the privacy policies, potentially looking into their employee contracts to see what they have, and they should probably be referring to those in any form of notification they make to employees, just to reiterate what they're doing, and equally the expectations that they have on employees in terms of how they're using the IT systems and equipment during the remote working period. And we moved to a number of new systems, particularly a lot of collaboration tools, things like Zoom, Microsoft Teams, various other ones that may have been installed already, but equally may have been installed quite quickly. So the key thing for employers to do here is really to have a conversation with their IT departments to really understand what they're doing from a monitoring position, because they may well be surprised that monitoring is a lot wider than they think it is, or they may think they're not monitoring at all and they actually are. And it's key things like, are they recording Zoom calls or Microsoft Teams calls? Now, for some DIFC employers, there may well be a regulatory requirement to do that anyway under the FSA, but it's important that DIFC employers really understand what they're doing and the extent of any monitoring. For example, are they monitoring private emails? Are they monitoring social media usage or internet time of their employees? Now, these may be things that from an employer point of view, they feel as if they want to keep track of what their employees are doing to ensure productivity. But equally, from an employee point of view, there may be an issue from a privacy point of view. Another interesting one on this section is, of course, it refers to employer assets. So that's IT equipment that's provided by the employer to the employee, whether it's laptops, tablets, whatever. So equally, the DIFC employers should be considering whether, in the circumstances where employees are actually using their own devices at the moment from remote working, does the employer have a bring your own device policy? What does it say? So the second point is a more general one, really placing an obligation on the employer to ensure that adequate cybersecurity measures are in place for remote working. And the directive makes the point that these need to be sufficient and acceptable from a reasonable industry standard, and that's the wording from the directive. Now, there's no definition of reasonable industry standard. So from an employer point of view, once again, it's a conversation with the IT team really to understand that the measures that they're taking could reasonably meet that requirement. Now, there's certain places that an employer can look for that. They can go to the Dubai Electronic Security Centre and look at the standards requirements there, the TRA, National Cybersecurity Strategy, and the various documents and standards that flow from that. And they can also look at international cybersecurity standards. But once again, it's important that employers have that conversation with their IT teams to make sure that what they're doing would fall within that reasonable industry standard definition. The other point on that one to draw out is the fact that it talks about ensuring adequate cybersecurity measures for the type of work that's being performed. Now, what that suggests is that there's not a one-size-fits-all response from a cybersecurity point of view. Employees may be dealing with very different types of data. There may be certain employees that are dealing with little to no personal data, sensitive personal data, confidential data such as financial data. So for them, there may be a lesser requirement from a cybersecurity point of view, albeit the organization may want to keep up a robust cybersecurity presence regardless of the data being managed and the type of work being done. But it's important that DIFC employers really review what their employees are dealing with and where they identify that employees are managing sensitive personal data, for example, some of the health data that we're going to go on and talk about, or financial data that would likely be confidential, that they implement different levels of security. And that needs to be pretty agile as different employees manage different tasks. So moving on to the health and safety, the balance really between health and safety and privacy obligations, and this is covered in the directive as well. And it basically sets out that employers may collect and process and share personal data with employees, and that does cover health data, including COVID-19 related symptoms, for any reasonable purpose related to the health and safety of their employees, provided, and this is important to note, provided that they should not process more information than is reasonably necessary. Now, employers have a legal obligation to protect the health and safety of their employees. And that's, certainly in these exceptional times, that's incredibly important. But also that there's a continuing requirement, and this is what the directive stresses, there's a continuing requirement to balance this against data protection obligations of DIFC employers, data controllers, basically, that they're managing that data that they collect. And this may, a lot of this data may be quite new for employers to collect. For a lot of people, we were signing in with forms at the front desks for a while when we were going for meetings with clients, and all that information is collected up by DIFC companies, and they need to be sure that they're processing that data fairly lawfully and securely, and what the data that they're collecting is adequate, relevant, and proportionate. It's not excessive, and it's important to look at that. So, for example, if the relevance is collecting COVID-19 data, then of course broader questions and the broader collection of information in relation to an employee's medical history or health history that's not directly relevant to the COVID-19 situation could be deemed to be not reasonably necessary for the purposes. Now, under DIFC data protection law, there are a number of legitimate purposes under which DIFC data controllers can process personal data. And certainly one of those is in relation to regulations and legal requirements. And then there's a large number of legal requirements out there that have been passed in relation to COVID-19, both from the Ministry of Health and otherwise. So there are protections for employers who are collecting data under the DIFC data protection law, and it's not stopping them doing it, but they need to be aware of what they're collecting, and they need to understand that data protection requirements continue to apply, and they need to be cognizant of that. And that's really the point of the fourth bullet point there, which talks about measures must meet the DIFC data protection law requirements. And the key point that the directive is making here, that with so much going on and the situation has moved very rapidly, it's very fluid, there's a lot of announcements that are coming out, and DIFC employers have had to react very quickly, put a lot of new things in place and do a lot of things very differently to the way they've done things in the past, and that includes collecting personal data. But the directive very much reiterates that all the continuing rights of data subjects exist under data protection law, and employers really need to refresh to the extent required what their obligations are under DIFC data protection law and any other applicable data protection laws, particularly around security of processing that data. And it's important, particularly as we come out of the COVID-19 crisis, that the data that's been collected by DIFC employers, that they review those to identify which data they need to be retaining and which they should be retaining under the DIFC data protection law, and which data they shouldn't be. So those were the key points around privacy and cybersecurity. And Gordon, I'll hand it back to you for the questions.
Thank you, Martin. We have a few questions which have been sent through, so thank you for those. Question number one is, when you say employers need to maintain a list of employees surplus to requirements, this is obviously for the available employee database. Does that mean employees who have been terminated due to redundancy, or those we are contemplating terminating for that reason? Which is a good question, and essentially the way that the directive is phrased is that employers shall during the emergency period be required to maintain a list of its terminated employees and, quote, employees that are surplus to its current needs. So to answer the question, I think if you're contemplating terminating for that reason but haven't made any definitive decision on it, then I would suggest that you have not then made a determination that the employees are surplus to your requirements. So I would suggest that at that point, you wouldn't have a positive obligation to include them on the available employee database. And that kind of chimes with the practical advice that the DIFC are providing via the Government Services Office, where they're looking for a termination date to be provided when the details for the individual are submitted. In addition, and this actually on a similar theme, the next question is the obligation to share the list of terminated employees, the question is it also applicable in case of resignation and/or mutual separation agreement? And then we go to the directive itself, where it defines terminated employees being those that the employer should maintain a list of for the purposes of the employee database. And terminated employees are defined as being any employee whose employment contract is terminated during the period 1st of March 2020 up to the end of the emergency period of 31st of July. So where an employee's contract is terminated by reason of resignation or by reason of mutual agreement, the prudent approach would be to assume that the obligation does apply and to ask the employee's consent if they wish to be included on the available employee database. Would be my view on that particular question. The next question that we have is as follows. As part of the COVID-19 directives, it says Ministry of Human Resources and Amortisation has decided to reduce working hours to 6 hours a day for employees in the private sector, Muslims and non-Muslims. Is this applicable in the DIFC? To be clear, the UAE labour law already provides for reduced working hours by 2 hours a day, and so it's not a new measure which has been introduced onshore. And likewise, albeit slightly differently, the DIFC employment law also provides during the holy month of Ramadan that a Muslim employee shall not be required to work in excess of 6 hours each day. It used to say a fasting Muslim employee before the law was changed in 2019. Now it just says a Muslim employee. So non-Muslim employees are not entitled to reduced working hours during Ramadan, whereas Muslim employees are entitled to reduced working hours during Ramadan, which is different to the onshore position where there's no distinction made between Muslims and non-Muslims for the purposes of reduced working hours. The next question is, how will the visa cancellation requirement be reimposed after 31st of July? And then it says, for example, will we have 30 days from 31st of July to cancel visas for staff terminated during the emergency period? Good question. There is no guidance within the directive around that. I would suggest from a practical common sense perspective, it's likely, and it's albeit that we probably could do with confirmation on that very point from the Government Services Office, that you would have 30 days from the end of the emergency period. But that's one where I think we would want to seek specific input from the Government Services Office as to how they're going to apply that, because it isn't made clear in the directive how that would work. Okay, just go to the next question. The next question is, we terminated an employee prior to COVID-19 taking effect. The notice period is ending during it says the ER period. I think that will mean the emergency period, and I'm contacting him to inform him about our obligation to share the list of terminated employees to the relevant authority. So I think the question is, if the employment relationship was terminated prior to the emergency period, but the termination date is during the emergency period, is there any positive obligation to enrol the employee for the purposes of the available employee database? And the answer to that would be yes, because the employment contract is terminated. The termination date is within the emergency period. Next question is, do we have to follow the directive list in order, or can we decide what's best for our company in relation to reducing working hours, imposing vacation, reduced remuneration, etc.? And I suspect the reason for that question is that the UAE Ministerial Resolution number 279 set out, this is for the onshore population, set out certain steps and required employees to gradually follow those steps. So rather than jump to step number 5, the implication within the UAE onshore resolution was that you follow the steps in order before you arrive at the final step in the tick box list. For this presidential directive in the DIFC, there are no such requirements. So it's any one or more of the measures, whichever is most suitable for your organisation. So you're not required to go through them in order as you might be expected to do in an onshore environment. Next question is, with regards to the DIFC available employee database, is it a mandatory requirement for the employer to do such a declaration? Well, yes, if it falls within the parameters of what I mentioned, terminated employees or employees that the employer is contemplating or surplus to requirements, and the decision has been made that they are surplus to requirements, then yes, there would be a positive obligation to provide their details to the database, providing that the employee consent has been obtained. Okay, well, we have finished the questions that have been submitted. So if anybody that has joined us has any further questions, you can see from the slide that Martin and my details are there. Please do feel free to reach out to us. In the meantime, we thank you very much for your time this morning. We hope the session was useful, and stay safe, and we look forward to keeping in touch with you. Thanks again. Bye-bye.